finish up with what I've been calling disfavored speakers. Let me give you a heads up for Thursday, which is when we start on libel. And the reading is the Dorsey case, Dorsey against National Enquirer, where a lounge singer named Engelbert Humperdinck sued the National Enquirer, the tabloid, for libel, for saying that he had AIDS. And what you should think about as you read Dorsey is forget about what was actually decided in the Dorsey case, look at the facts of what they published about him, what he did, and so on, and think about what he has to prove to make his case for libel at common law. That is, before New York Times versus Sullivan was decided in 1964. Sullivan constitutionalized the law of libel and made every libel case a First Amendment case. But try to keep that in the background and look at Dorsey as a pure common law case, where the state common law rules applied before Sullivan was decided. And we'll look at what the elements of the case for libel were up until the point where Sullivan took over and made every case a constitutional case. And let me say a word about B-Space. Way too many of you are ignoring it completely. Remember, the instructions were that I expect you to check it at least once a week minimum. I highly recommend that you do that. Stay in touch with what's going on that way and participate to the extent that you want to. You get participation credit for doing that. Okay, disfavored speakers. Disfavored both because of who they are and how repugnant their speech is to people. These are not popular speakers that we're considering here. And the first group are the Jehovah's Witnesses. And they have been prolific litigants in the United States Supreme Court over the decades. You would think that this religious group, somewhat persecuted and disfavored, would be in there fighting for their rights under the religious clauses of the First Amendment, their right to freedom of worship, their right to resist a government establishment of religion. But in fact, the most important cases that the Jehovah's Witnesses have been involved in involve the speech and press clause of the First Amendment. And they have established, for the benefit of all of us, real important principles of freedom of speech and the press. They're not likely users of the legal system because of their beliefs that all of the answers are in the Bible, not in law books. And they avoid all involvement in politics. They discourage voting. They refuse to serve on juries or in the military. So their role as involving the First Amendment has been somewhat forced on them. One of the obligations that, this is the headquarters of the Jehovah's Witnesses congregation, I'm not sure what you call a church, in Brooklyn, and their Kingdom Hall, their places of worship are spread all over the country, of course, all over the world. And one of their obligations as Jehovah's Witnesses is to preach and to proselytize and to go around and try to persuade and convert people who don't get it. And they do that by passing out their brochures, the Watchtower, and other brochures on street corners to passers-by, going door to door, knocking on doors, and we've all seen them. And this emphasis on proselytizing and going door to door has not endeared them to many towns and villages and some cities around the country who have viewed the Jehovah's Witnesses' activities as a nuisance, a bother, an interruption for people that they would rather not deal with. I don't want to listen to you, I don't want to have you on my doorstep, that sort of thing. And so various towns have enacted laws. The American way, there ought to be a law. Various laws to deal with the presence of the Jehovah's Witnesses in their communities. And the first case that involved the Jehovah's Witnesses that went to the Supreme Court was the Lovell case. Amy Lovell was arrested in Griffin, Georgia, back in 1938 for distributing her Jehovah's Witnesses literature without the law required that you first obtain a written permission from the city manager in order to distribute literature. And Amy Lovell had not applied for a permit because she regarded herself as sent by Jehovah to do his work. She was arrested, convicted, sentenced to 50 days in jail for distributing her literature. And the case, the Jehovah's Witnesses took the case to the Supreme Court, which decided that, like in Yetta Stromberg's case, the ordinance was invalid on its face, invalid in all of its applications. The court emphasized that the law prohibited distributing any kind of literature, whether it was newspapers, magazines, leaflets, what have you, at any time, in any place, and in any manner, without the permission of a government official. So the court said that struck at the very foundation of freedom of the press by subjecting it to license and censorship. The court treated what the witnesses were doing as a restriction on the press, not on religion. And the court said the liberty of the press is not confined to newspapers and periodicals. It necessarily embraces pamphlets and leaflets. That's the lonely pamphleteer that we use as our metaphor out on the street corner handing out her leaflets. She's as protected by the First Amendment as the publisher of the New York Times. And the court referred to famous pamphlets in American political history like those of Thomas Paine at the time of the Revolution and the important role that they served in our political society. But the principle established by Lovell versus the city of Griffin, that the exercise of First Amendment freedoms can't be made subject to licensing and government approval, has had broad application, used repeatedly in the civil rights movement for demonstrations, for example, where a common reason, a common excuse for a town to not permit civil rights demonstrations was parading without a permit. You can't come into our town and parade without a permit. Government approval in advance for what you wanted to do in the way of First Amendment activity. The Lovell principle has also been used by magazine distributors, film distributors, and others. And we always assumed under our constitutional system that the press could not be licensed you can't require a license from the government in order to practice journalism. We'd always assumed that, but it was the Jehovah's Witnesses case that made it the law. The Jehovah's Witnesses established not only the right to speak and to proselytize, to distribute literature and so on, they also established, for the benefit of all of us, the right not to speak, the right not to be coerced by government to say things that you didn't want to say. And the case that established that came up in the context of a flag. And unlike Yetta Stromberg wanting to raise and salute her flag, the Jehovah's Witnesses believe they are religiously forbidden to bow down to a flag. They treat it as a graven image. They refuse to salute the American flag or recite the Pledge of Allegiance to the flag or sing the Star-Spangled Banner. Well, all this came to a controversy in wartime, in World War II, and in the patriotic, I don't want to say hysteria, but ethic of the day, various school districts around the country began requiring flag salutes as part of public school students' daily routine. Back in the 30s and right up to the beginning of the war, the required way to salute was this Nazi-looking salute that school children used. And when President Roosevelt realized that that's what students were doing and that looked like what the Nazis do, they changed the way you pledge allegiance to the way we do it now. Well, the practice of requiring students to do the Pledge of Allegiance was challenged by the Jehovah's Witnesses because they religiously couldn't do it. And a case went to the Supreme Court called Gobitis. And the court upheld the requirement of saying the Pledge of Allegiance. In an 8-1 decision, the compulsory pledge was held constitutional. It was an opinion by Justice Felix Frankfurter, who was a very famous, extremely intelligent, creative justice of the court. He'd been for a long time a professor at Harvard Law School, and he was a judicial restraint type justice. He emphasized in the Gobitis case, the limited nature of judicial role. He didn't want the court to become the school board for the country. And reasoned that it was permissible to use the salute to promote the interest in national unity, which he said is the basis for national security. Well, the Gobitis decision was followed by some unpleasant days in which the Jehovah's Witnesses were physically attacked, their houses of worship were vandalized, their property was trashed. The First Lady, Eleanor Roosevelt, publicly called for calm, leave them alone. Newspapers editorialized that the Gobitis decision had been wrongly decided, and 3 of the justices in the next Pledge of Allegiance cases to come to the court dissented. And so it looked like the Pledge of Allegiance issue was still up for grabs when the West Virginia Board of Education instituted a mandatory pledge, and the Jehovah's Witnesses, of course, refused to participate. Their children were expelled from school, threatened with being sent to reformatories, and their parents were threatened with prosecution for causing truancy. The court stepped in, changed its mind, and established some really important First Amendment principles in the Barnett case, including the right not to speak. Justice Robert Jackson wrote a wonderful, eloquent majority opinion pointing out that we're dealing with a compulsion of students to state a belief. And the issue is whether in our democracy the majority may compel citizens to state political beliefs that they may not hold. And the court rejected the state's argument that the flag promoted national unity, saying that national unity unquestionably is something that officials may foster by persuasion and example, but they can't do it by coercion. And the court determined that the Jehovah's Witnesses children could not be compelled to salute the flag. Well, that provoked a dissent by Justice Frankfurter, of course, pitching it on judicial restraint grounds. But he starts out, he was a Jew, he starts out saying, one who belongs to the most vilified and persecuted minority in history is not likely to be insensible to the freedoms guaranteed by our Constitution. Were my purely personal attitude relevant, I should wholeheartedly associate myself with the general libertarian views in the court's opinion. But as judges, he says, we are neither Jew nor Gentile, neither Catholic nor agnostic. We owe our equal attachment to the Constitution. And it's the duty of a judge, who must decide who wins, to put aside his own opinion about the wisdom or the evil of a law. That should be excluded from the judge's mind when he's doing his duty on the bench. It's a classic statement of judicial restraint. The idea was, or one of the ideas in Frankfurter's opinion was, we as a court, as judges, ought not to interfere with the democratic process and the judgments of democratically elected state and local officials who decide that the pledge is a good idea. We're not a super legislature, he says. And he cautioned about being so preoccupied, as we seem to be in America, with the constitutionality of laws. Constitutionality, he says, is not synonymous with wisdom. Courts have to accept unwise laws. And with regard to legislation on speech, courts ought to recognize that much which should offend a free-spirited society is constitutional. And instead of looking to the courts, we ought to look to the convictions and habits and actions of a community to guard against the temptation to fetter the human spirit. It's beautiful rhetoric, but it's wrong. It puts the rights of free speech and the rights of minorities at the mercy of majorities. If you follow Frankfurter's reasoning, there would be very little in the way of free speech that did not appeal to the great majority of citizens. And in any event, Frankfurter's view did not appeal, and the Pledge of Allegiance cannot be made mandatory for somebody who doesn't want to do it. Justice Jackson concluded with this: if there's any fixed star in our constitutional constellation, it's that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith in what's orthodox. Well, that's a useful contribution that the Jehovah's Witnesses made, and a variation on that right to speak problem came up in a more recent case involving license plates. The New Hampshire license plate has this slogan on it, which is a little enigmatic: "Live free or die." I mean, it reminds me of "Long Hits for Jesus." You're not quite sure what the implications of that are, but a Jehovah's Witness in New Hampshire by the name of George Woolley objected to being coerced by the state into advertising a slogan that he found to be morally, ethically, religiously, and politically abhorrent. So what he did was he took duct tape and put it over the slogan, over the "Live Free or Die" slogan on his license plate, and he was arrested and convicted of a misdemeanor for doing that. The case went to the Supreme Court. The justices looked back to the precedent set by the Pledge of Allegiance case, viewed this as a form of coerced speech, requiring Woolley to adhere to an ideological point of view that he finds unacceptable, and the right to refrain from speaking at all is a part of the First Amendment. Forcing a citizen to be what the court called a mobile billboard for the state's ideological message invades the sphere of intellect and spirit, which it is the purpose of the First Amendment to reserve from all official control. Well, that's good, but not every time the Jehovah's Witnesses have been to the Supreme Court has resulted in enhancing First Amendment rights. There is, alas, the Chaplinsky case. Walter Chaplinsky was out doing his Jehovah's Witnesses duty on the streets of Rochester, New Hampshire, when he attracted a crowd who were not pleased with what he was saying when he denounced all religion, all organized religion except the Jehovah's Witnesses, as a racket. And a city marshal, law enforcement officer, warned him to go slow because the listeners were getting upset. And a police officer took Chaplinsky by the arm and walked him toward the police station without arresting him. And on the way, they ran into the same city marshal who had stopped him initially, and they got in an argument about whether anybody should be arrested, including the unruly listeners. And Chaplinsky took the opportunity to call the marshal a goddamn racketeer and a damn fascist, adding for good measure that the whole government of Rochester are fascists or agents of fascists. So Chaplinsky gets prosecuted under a state law that prohibited anybody from addressing any, quote, offensive, derisive, or annoying word to any other person in a public place, or calling him by, quote, any offensive or derisive name. And the Supreme Court affirmed the conviction. Chaplinsky lost. And the court reasoned that there are certain well-defined and narrowly limited classes of speech, categories, I call them, classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem. These include the lewd and the obscene, the profane, the libelous, and the insulting or fighting words, those which by their very utterance inflict injury or tend to incite an immediate breach of the peace. These kinds of utterances are no essential part of any exposition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. Well, there's a lot to chew on there. Chaplinsky was the first case to explicitly recognize categorical exceptions to the First Amendment protection for free speech. It had always been assumed that obscene material was not protected, although it hadn't been very carefully defined. And libel, of course, at least before Sullivan, was considered to be unprotected speech. And to those categories, the court adds fighting words. And the test that the court uses for fighting words, those which by their very utterance inflict injury or tend to incite an immediate breach of the peace, is what the court means by fighting words, a category of speech that the... could you ask her to stop doing that? Thank you. If you don't want to pay attention, you can go outside. The idea that the court uses with regard to this category of speech is that it's a kind of a balancing act. The social value of the speech in question is weighed against the harm that that kind of speech causes. And as the balance tilts in favor of the competing social value of the peace and quiet, don't disturb the peace, don't get people upset, then the speech is in a category where it's unprotected. It's an extremely dangerous notion for freedom of speech.